Professors Barnett and Rappaport. And before we begin, let me give you a little bit of background about the subject matter of the debate and also our debaters. I think it's fair to say that originalism is a flourishing theory of constitutional interpretation. There are prominent proponents on the bench and in the legal academy, and many of them are here today at this gathering. There's been increased sophistication of intra-originalist debates, such as the one that we're having today. And there's been increased attention, and usually or often criticism, by non-originalists who I think are perceiving originalism as a viable interpretive methodology and who are responding to it as maybe a threat to the dominant non-originalist methodologies out there. But of course, the flourishing of originalism doesn't come without growing pains. There's a vigorous debate about what form of originalism is the proper type of originalism: original intent, original meaning, original understanding, original methods originalism. There's also vigorous debate about what the normative justification is for originalism. We have folks who argue that originalism is the best interpretive methodology to advance and protect individual natural rights. We have others who argue that originalism best leads to the best consequences. Still others argue that it best facilitates popular sovereignty, and others argue that it promotes human flourishing. Today's topic is one of those areas of vigorous debate. Constitutional construction has risen, or the concept has risen to prominence in the last decade. It's been promoted most prominently by Professors Whittington, Barnett, and Solem. And the basic idea is that the Constitution's original meaning, its authoritative meaning, at some point runs out. It becomes underdetermined. And this leaves interpreters with discretion, and it requires interpreters to utilize non-originalist considerations in order to construct the Constitution's meaning in that context. And so there's a lot at stake in this debate over whether or not constitutional construction exists, and if it does, what are its characteristics. On the one hand, for the pro-construction folks, what's at stake is the viability of the new originalism, of the original public meaning originalism. On the other hand, for folks not enamored of constitutional construction, what's at stake is the distinctiveness of originalism as a method distinct from non-originalist methodologies. And I think somebody in the non-construction camp might point to Jack Balkin as one of the problems, so to speak, that arises when construction is invited into originalist interpretation. To debate the existence of constitutional construction, we have two prominent scholars in the area of originalism, Professor Randy Barnett, Professor Mike Rappaport. Both are familiar faces here at the Federalist Society. Both are prolific authors and scholars in the area of originalism, and both are articulate and vigorous advocates of their respective positions on constitutional construction. Professor Rappaport will take the anti-construction position. He'll speak first. Professor Barnett will take the pro-construction position. He'll speak second. Each person will speak for approximately 10 minutes, and then we'll have a 5-minute rebuttal. And Professor Barnett won't respond to Professor Rappaport's comments in his initial comments, and instead will save any responses for comments made here for his response. So, Professor Rappaport.
Thank you, Lee. It's a great pleasure here to be having this debate conversation with Randy on these matters. Okay. So let's assume for a second, is there feedback here? Let's assume for a second that we're all originalists here. Now imagine that someone came before us and argued that what we ought to do is to interpret the Constitution based on the libertarian theory of justice. Instead of following what the Constitution has written in it, what we ought to do is to follow what libertarianism tells us to do. Alternatively, if you're not a libertarian, then you ought to follow whatever normative theory you regard as legitimate. Now, would an originalist favor such an interpretive methodology? Of course not, right? That's simply not originalism. Now, imagine that instead of interpreting based on a normative theory, someone recommended interpreting based on a normative theory half of the time. Half of the time you'd follow what was written in the Constitution. The other half of the time you would follow the normative theory. Right? Would an originalist favor this interpretive methodology? And again, I think not. Well, if an originalist wouldn't sign on to this latter interpretive methodology, where you follow the normative considerations half the time, then I don't think he would favor following construction either. Because this latter method of following normative considerations half the time is very similar to construction. Right? According to Randy and other constructionists, Larry, that's blinking at me. Over and over again. Sorry. So according to Randy and other constructionists, while judges should follow the original meaning of the Constitution, the original meaning is often ambiguous or vague, and therefore it runs out. And when it runs out, the interpreter should resolve ambiguities or vaguenesses based on the normative theory that they regard as legitimate. And thus, construction allows interpreters to enforce, as constitutional law, their normative views a significant portion of the time. Now, I think the main reason why construction is a more popular theory than these interpretive methodologies that I started out with is that some people believe there's really no alternative to construction when the original meaning runs out. I mean, if there's no original meaning, then why not consider normative matters, right? What else is there? Well, today what I want to do is to challenge construction. And I want to argue that its claim that the original meaning runs out and allows for interpreters to base their decisions on extra constitutional normative matters is really a dramatic and undesirable departure from traditional originalism. I also want to show that going outside the Constitution is not necessary. Instead, I want to argue for a different approach, an approach called original methods originalism that John McGinnis and I have developed in a series of articles over the years, and that this approach operates to resolve ambiguities and vaguenesses. And therefore, it minimizes, possibly even eliminating the need to go outside the Constitution to resolve these matters. Okay, so we can look at originalism or any interpretive theory from really two different perspectives. And one is an interpretive or a positive perspective, which is to ask, how well does that interpretive methodology actually capture the meaning of the document? And the second perspective is a normative perspective, which basically asks, how desirable is this interpretive methodology? And what I want to do is to explore constructionism and original methods from the perspective of each of these perspectives.